It cared about it in the way that you're talking about, but really the relevant focus, I think, needs to be on what it was doing in this statute. And what concerns me about the way you've set this up is you are suggesting, I think, that the preemption part of this was also covering state regulations with respect to brokers as they relate to safety, and that then when Congress came in and put in the savings clause as a part of this, it was leaving brokers preempted with respect to what they do that might implicate safety. But that's not the way I think the statute reads. It seems like the preemption is smaller than you're giving it credit for to begin with.
The preemption is very broad, as, again, Mr. Clement kindly outlined. Transportation of property that's what's preempted.
No. Laws related to a price, route, or service of any motor carrier.
Or broker with respect to transportation of property.
But I think what's doing a lot of the work in this, in understanding the scope of preemption, is the states may not enact or enforce a law related to a price, route, or service. And if you read it that way, then the savings clause is focused on what the state can do concerning safety.
No, well, it is, Your Honor, but it's safety with respect to motor vehicles. And the preemption clause, we're not disputing that a tort claim that targets the services of the broker. And this goes to the essence, as the Seventh Circuit said, as Aspen said in the 11th Circuit. This is the essence. What brokers do is match the carrier. Counsel's depiction of what brokers do is completely divorced from reality. They're not interviewing and investigating. They're matching up federally approved carriers with shippers. And they want them to be safe because they want their shipper clients to keep hiring.
There's no duty of the broker to check the safety records when it's doing that match?
No, Your Honor. In fact, they're supposed to rely on the federal government's licensing. That's what the court said.
As a matter of state law? The state could not impose a duty on them to make sure that they pick and match the best in terms of safety record?
That's exactly the question in this case, Your Honor. And if you look at the complaint, JA 22 through 26, they're asking this court to greenlight the states to impose duty after duty.
What was the status quo? Was the state able to hold a broker liable before this action, before the preemption, for things like what is happening in this case?
No, Your Honor, we don't believe they were. We think this court's Castle decision talks about how the states could not second-guess the federal authorization of a carrier because it would thwart uniformity, it would thwart commerce. This isn't a traditional area of state prerogatives. This is about interstate commerce and the free flow of interstate commerce.